Hi, I'm Addie Pruitt, a New Orleans based estate planning and tax lawyer. I collaborate with forward thinking clients to preserve their property and pass their legacy and prosperity to future generations. Today, I'm got some new audio gear here that I'm trying out. So hopefully, you will not hear the people across the street that are doing all the banging on the house next door. But if you do, my apologies in advance. So today we're going to be talking about new-ish rules for retirement accounts. And the reason I say new-ish is because they actually came into law in 2019. But if you remember, right when they came into law, 2020, we were in the middle of a global pandemic. I don't think this was on a lot of people's radars, nor were they real concerned about it at that point in time. But I wanted to kind of talk to you a little bit about what happened, what the changes were, a quick illustration about that, and some things you can think about doing to kind of mitigate those changes. So, what I'm talking about is the Secure Act. One of the changes that you may have heard of is it increased the required minimum distribution age from 70 and a half, which was always a super weird age in my opinion, to age 72. So now you don't have to take anything out of your retirement accounts if you don't want to until you reach age 72. However, another thing that it did was it did away with what was called the stretch IRA. So prior to this law going into effect, if someone died and let's say their child inherited a retirement account from them, the child could then use their life expectancy to decide how much they needed to take out of the account. So if you had a 38-year-old child, I believe you had 45 years to take the amount out as needed over that time. So if you think about that, it's growing as it's sitting in that account. So it was a great opportunity to pass wealth on to children, but unfortunately, the Secure Act did away with that. So now spouses can still use some of those life expectancy rules, but generally children, which is probably what we're most concerned with here, have to take all of the money out of the account within 10 years. So, if you think back to that 38-year-old child, if the parent dies in 2020, they have to take everything out of the account in 10 years. And the reason why that is so important to think about is we're talking about qualified retirement accounts here. So these are like your 401ks, IRAs, things that you have put money into without paying the tax. So this is not the Roth that we're talking about here, but instead stuff that you're kind of you've not paid the tax on that yet. And so when your heirs go to pull that money out, they will owe tax. Generally, it's going to be at ordinary income tax rates. From a tax perspective, it's considered income in respect of a decedent, IRD. That's getting way in the weeds, probably more than most people here ever want to know. But the problem with it is if you, let's say, okay, I'm going to wait 10 years and then I'm going to pull it all out. Well, remember, you're paying tax on that. You pay tax on graduated income tax rates. You pull a whole lot of money out, your tax rate skyrockets. And so it really has, done away with some of the traditional planning in this area where you could plan to take that money out over several years. Now, there's some things you can do, obviously, to kind of not have this issue. One is that you can spend down the IRAs. Maybe you didn't think you were going to need the money in the IRAs, you just wanted to leave it to your kids, but now it's like, I can go ahead and pay that tax now and pass some other assets that aren't going to be subject to those ordinary income tax rates. So that's one planning technique that a lot of people are thinking of, a lot of people are doing. You can divide, if this is depends on the size of your family and obviously what you want to do, but you could divide your designated beneficiaries. Maybe before you were just going to leave it to your children, maybe you want to add grandchildren, some things like that, so that not each person has that big hit. Of course, they may like the money, so that's another thing that could go wrong. Another thing that people can do is you can actually convert those to Roth IRAs during your lifetime. That way you will be immediately picking up the tax. But if you do it sort of in a thoughtful way, you can do it so that you're kind of, not getting yourself into too high of a tax bracket, but also that way when those funds are then passed on to your children, they don't have to worry about that big old income tax waiting for them on the other side. And another thing that people have been thinking about using are charitable remainder trusts. And I think this is probably, where we're going to spend most of the time of this conversation talking about what those are and what some of the benefits are of those things are. So a charitable remainder trust is a split interest trust. It is an irrevocable trust that you create during your lifetime. You will name a charity as the remainder beneficiary, and then let's say it's children, they can get a stream of income. It's usually 20 years or based on their life expectancy. And then at the end of that term, whatever's left in the trust passes to the charity. So automatically you're probably thinking, Addie, that sounds great. I can pass all this money on. But there are rules that if unless you were charitably inclined, this is probably not the best way to pass generational wealth, we'll call it, on to children, because the charity at the beginning, when the account is set, has to receive at least a 10% remainder interest. It can grow or decrease, based on what the market does, what the funds are invested in. But because you have a large chunk automatically going to the charity, generally, if you just gave the money outright to the kids, even with them paying the tax, they probably would, at the end of the day, receive more money. But if you want to be charitable, this is a great way to make those dollars go further, so to speak. And so a charitable remainder trust is defined as a trust which provides for specified distributions, at least annually, to one or more beneficiaries, one of which is a charity, for a term of years. And then at the end is paid over to the charity, kind of like what we talked about before. And so because of the Secure Act, which we used to use to kind of like, that stretch our IRA, the kids could get the money out over several years. People have suggested this might be an alternative to it. I do think it's a great alternative if you are charitably inclined. If you're not so charitably inclined, though, like I said before, it's probably not going to maximize the amount of money that you transfer to your children. But I did kind of want to talk through what it would look like. In terms of you did this, and one of there are common ways to do this. One is to give you name your spouse as you name the charitable remainder trust. You make your spouse sort of the income beneficiary of that trust, so they can they'll take their and amount out each year based on their life expectancy, and then at the end it goes to charity. So that's kind of like a very simple way where you're providing for your spouse through with this charitable remainder trust, but then at the end it's going to charity. And if you name the trust as sort of the life expectancy of your spouse, I think people worry or wonder what that means. So if your spouse lives for another 30 years, then they are taking the income from that trust assets for those 30 years. And then at the end, whatever's left goes to charity. The other side is that if the spouse only lives for 3 years, whatever is left in that trust goes to the charity. So you can't do that and kind of give it to your kids. Another thing that people do kind of in this is called the give it twice trust. And it's sort of if you Google "give it twice," you will see Texas A&M come up right on point on this, which I think is hilarious, just because it's Texas A&M, they have all the oil money, but and I'm a big LSU fan, so they're a big rival of ours. But essentially, what it says is, okay, so we have that IRA. We're going to split it. We're going to give the children a 20-year term for the money in it. Let's say a 5% of whatever's in that trust. So, and an $800,000 trust, 5%, the kids are getting $40,000 per year. And then at the end of that 20 years, the rest goes to charity. And the reason it's give it twice is because if the numbers work out right, you're essentially giving the same amount to both your children and the charity. So the charities love that. They get the money, and the kids also, they have a stream of income coming in for that 20 years. So that could be great in the sense that if the kids are fine with that extra stream of income, who's not fine with extra money, I suppose. But the kind of the detriment to the kids could be, let's say they have some large expense, want to pay for a wedding, want kids college, something like that. They can't just go in and get extra money out of that trust. They just can only get whatever, think of it as an annuity, because that's really what it is. Or unit trust amount, but that's kind of getting into the weeds. But it's, the certain amount that's coming out to them every year. The reason people kind of like this give it twice trust, though, is like when we talked about before with the life expectancy, when the income term is based on the life expectancy of a person, it could be large, it could be small. Unfortunately, that's not something we can predict. If we were, this would make all of our jobs in this space a whole lot easier. But the good thing about the sort of the give it twice trust is if you have a child that you name as that, let's say they unfortunately die early, then their children can kind of step in and take over that term for the remainder of the 20 years. So it doesn't just all go to the charity. So I think that's kind of a good way to protect both your family and your charitable, remainder interest. So that's a brief, very high level overview of charitable remainder trust. But I thought this was kind of important, and I don't think people often think about the ways that they could give to charity, especially if you think, well, wow, it's give it twice. I could, give that same amount to my kids and to a charity. I think people are interested in that, particularly if they don't plan on using their retirement savings. Maybe they sold a business for, millions of dollars. They've had this 401k, but they don't actually foresee the need for it. These are really good opportunities to advance some charitable inclinations that you may have and also benefit your children. So that's kind of the main thing I wanted to talk about. But I did have two more quick hits that I kind of wanted to share with you. The first of which is I saw this article. I'm going to try and pop it up in the stream. Let's see if this will work. Uh, Give me one moment. Okay. All right, here it is. Here's the title, which I was just like, oh my goodness. Naomi Judd left daughters Ashley and Wyona Judd out of her will. And I read that. I think, I came across maybe, unfortunately, on those notifications that I have. And I was like, wow, like they're about to go on tour. I wouldn't have thought she would have cut them out completely. That seemed a little bizarre to me. And so, of course, clickbait for an estate planning attorney is I have to go ahead and open this article. And the very next provision, in the very next sentence, I was like, oh, and it says, the late country singer appointed her husband, Larry Strickland, as executive of her estate. And I just kind of chuckled to myself because the way the article made it sound was that Naomi Judd left nothing to her daughters. When in essence, the only thing that people know, or the newspaper writers know, is that the executor of the will was her husband, and he filed probably the will, probably not even a will, but just let's open the estate. And so, I thought it may be a good opportunity to kind of talk about what an executor is and why being named executor has nothing to do with whether or not you have been left out of the will. So the executor is a person that in an estate succession probate situation is responsible for gathering all the decedent's assets, making an inventory of them, and then passing them on to the heirs. Either if there was a will, the people named in the will, or if it's an intestate, they'll probably be called the administrator in Louisiana, and passing them on to the people that the law says should get the property. So it has nothing at all to do with whether Ashley and Wyona are getting any money from the estate. It's just that her husband, surviving spouse, Larry Strickland, was named as the executor. I'd say that's very common. 99% of wills I write for married couples, probably 100% of the wills I've actually written for married couples, name surviving spouse as the executor. It does not mean that the children are not getting anything. I mean, it could not, but it does mean that the surviving spouse is just a person that is responsible for being the executor, for having that fiduciary obligation of gathering all the assets, reporting what there is, and then distributing it out as determined by law, whether that be a will or a intestate. So I just thought that was really funny. This has nothing to do with whether Ashley and Wyona got left out of the will, and so I wanted to just kind of bring that to people's attention, and hopefully that clarified. If you like me were like, oh, that seems odd, that is why. The other thing I just wanted to quickly mention was that there's loan forgiveness coming for $10,000 for some people. Most people, I guess, depending on your income. There's an application that you're going to have to fill out. I think that's coming out sometime next month. So if anything comes on that, I'll obviously kind of get that over to you guys as well. And then a little bit about me. I just thought I'd throw this in here. I have a 5-year-old who started kindergarten. It's pretty awesome. He loves school. I love school. So I'm so happy that he loves school. But probably the biggest news was I got to take him to the LSU Florida State game, which I did not like the outcome, but it was so exciting to take him. He was yelling, doing all the LSU cheers that I had taught him. Skipping around the stadium. It was, I think everybody who saw him just had a huge grin on their face. So, and don't worry, the 3-year-old's covered too. I'm coaching a soccer team. So we're all covered here, but that's all I have for you guys today. You know the drill. If you have any, you want to see other episodes, you want to catch up on anything, you can do that by, if I can get this to work, going to the website, addiePruittLaw.com, has all the old episodes of the live videos. And also, if you have any questions, you can email them to questions@addiePruittLaw.com. I will answer them on the air, maybe in a blog post, something like that. Note that if you send me anything there, I will assume that I have permission to share it. So please do not send anything that is confidential. And I will also send you an email saying that as well. But, get those questions in. I'd love to be able to answer people's questions on the show and kind of go about it that way. So that's all I have for you guys today. Thank you to everyone who joined in live. I appreciate it. And take care and have a great day. All right. Talk to y'all next month. Bye.